Duane Lahti, 4890 County Highway B, Iron River, Wisconsin. I'm a lifetime resident of Bayfield County here in northern Wisconsin. I'm also a retired DNR employee who worked in the water program for 29 years here in the Lake Superior Basin. I'm very familiar with the location of the proposed mine in the Penokee Range. I'm going to talk overall about the project, and I'll try to stay under my 3 minutes certainly, but please consider these comments that I'm making applicable to also the bulk sampling and the pre-application phases of this proposal. When I reviewed the limited information available for this mining project and the proposed location, I looked at it from the perspective of an environmental regulator, as I was just that for nearly 3 decades up here. Basically, I asked the questions: can a permit be issued for this project based on the physical and biological conditions at this location? Will this project meet the public interest standards that have been in place in Wisconsin environmental law for decades? Can this project be completed without jeopardizing human health and safety, and will it be in the public interest? My conclusion was that due to the significant and severe adverse impacts to surface and groundwater resources, wetlands, ephemeral ponds, streams, and air and terrestrial resources that would occur if this project were to be permitted, the project cannot and should not be permitted by DNR or any other regulatory agency. You could not find a more unsuitable area for a mining site unless you would put the mine on the bed of Lake Superior itself. And speaking of Lake Superior and the Kakagan sloughs, which are on the downstream and receiving end of the surface runoff and effluent and the repository for millions of cubic yards of overburdened waste material, these are internationally recognized resources and priceless gems that the citizens of this state and adjoining states and provinces have strenuously protected for generations, protected for future generations. Just like Article 9, Section 1 of our Wisconsin Constitution has protected all of our state's waters since 1848. Well, the mining company, GTAC, the governor, and the legislators who are pushing this proposal knew that if this proposal came before a regulatory agency under the existing mining law, which was designed to prevent environmental degradation and to protect human health and safety, it could never be permitted. The solution: gut the mining law and severely weaken the ability of the DNR to adequately regulate the mine and even to enforce permit violations. Unconstitutionally remove surface water bodies from protection of the public trust doctrine that has its roots way back to the Northwest Ordinance of 1787, and declare that streams are no longer streams but trickles, and that lakes and ponds are puddles that do not deserve protection. Also, limit the public's ability to provide input and to legally challenge decisions made by the department. I was fortunate that during my career with the department, our upper management consisted of natural resource professionals dedicated to our mission to protect our natural resources and environment for future generations. Our mission statement did not say open for business. I have the utmost respect for the DNR staff who work daily and have to make difficult decisions that affect all of us in the general public and are subjected to the political pressures that are today's reality. I know and I hope you will do the right thing. Resist the political pressure. I always did. Do a thorough and objective evaluation, and I am confident that the project will be denied for the benefits of our citizens and for those that come after us. Thank you.